Okay, so let's start. Hi, everyone. Welcome. My name is Pedro Garcia. I'm a partner and head of mining at Veirano Advogados. And thank you very much for joining this webinar. We're really excited because we're going to have a direct discussion between some of the most important international royalty companies with the National Mining Agency and the National Development Bank, the BNDES. As we all know, mining companies thrive for capital. Capital raising is a day-to-day exercise. And in this context, royalties come out as a very good alternative. I have the impression that in Brazil, although royalties are traditional, we still need to spread the information with more detail so that companies have a better idea of the opportunities there are around, even internationally, with the mining agency and the BNDES also giving us their positions and how we can perhaps offer some ideas and insights on how to improve the regulations so as to provide more legal security, transparency, and enforceability on the royalties. So in this scenario, last year, the National Mining Agency, in a very good step forward, put out a public consultation number 3 of 2020, with a draft resolution, which is intended to regulate Articles 43 and 44 of the Mining Code regulations, which essentially provides for the possibilities of offering mineral rights as security in different types of financings and capital raising transactions. So I'm sure there have been a significant number of contributions by the industry. We also offered some contributions. So before the resolution is actually issued, we thought it would be a good opportunity to have this discussion with the private sector, the international view, so that we can, get some good results and ideas for the resolution and for, at the end of the day, to boost capital raising for Brazilian mining companies. So first of all, I would like to say a big thank you to each of our speakers. We're really honored to have each of you. I'm going to make a very brief introduction, and then I'm going to just ask you to briefly say a little about your position and your companies, so that our viewers can understand better on the views you're sharing. So we're very honored to have Debora Puccini, who is a director at the National Mining Agency. We also have Yoshihiro Nemoto, who is the Superintendent of Regulations at the National Mining Agency. We have from the BNDES, we have Pedro Paulo Dias, who is a Market Intelligence Manager, and Letícia Vaz, who is a BNDES Legal Manager. On the private side, we have Randy Sheffman, who is the Vice President and General Counsel at Royal Gold. We have Warren Beil, who's the General Counsel at Mavericks Metals out of British Columbia, Canada. And we have the participation of Kyle Floyd and Simon Cooper from Vox Royalty, which is one of the fastest growing royalty companies. So really top-notch speakers. I think we have much to learn today. So I'll start with Debora. Thank you very much again for joining. If you could just, and please feel free to speak in English or in Portuguese as you wish. And we do have translation for our viewers. It's just you have an option of interpretation. And Debora, if you could just say, you know, how the resolution is moving forward, that would be great.
Bom, boa tarde a todos. Desculpe aqui o ambiente de fundo, porque a gente tem aí estado numa agenda bem apertada e bem complicada, mas eu trouxe aqui junto comigo o Yoshihiro, que é o nosso superintendente de regulação, para até fazer uma apresentação para vocês de como que vai ficar e como tem andado e evoluído a questão da resolução de garantias e de recursos de reservas, que são pontos fundamentais para que a gente leve a agência de mineração ao patamar internacional que ela merece. Nós estamos aí num processo já bem maduro de evolução das resoluções e muito já se evoluiu, e a gente tem agora uma premissa de colocar essa resolução já está em avaliação dos nossos procuradores federais, né, Procuradoria Jurídica, e daí a gente vai tão logo fazer a distribuição para um de nossos diretores, eu ou os outros 3 diretores, para fazer a relatoria e daí fazer a aprovação da resolução. Claro que, sempre lembrando que por ser uma resolução ainda primeira, né, vai ser a primeira da agência e também da história da mineração no país, vai sempre estar sujeita a alguma ou outra melhoria. E aí, claro, que a gente vai sentir com o mercado e com os senhores também como que nós vamos poder aprimorar. O importante de ser uma resolução é a questão dela poder ser adequada e adaptada e, claro, sempre modernizada à luz dos aspectos temporais, né? Nós agora podemos assim trabalhar com uma questão mais leve do que portarias e decretos que eram muito engessados e nós não tínhamos como nos adaptar às evoluções globais, da economia global, da economia brasileira, no caso, e também dos diversos investidores interessados. Então, com a resolução, a agência consegue ter essa mobilidade de estar sempre aprimorando e melhorando. Então, eu vou pedir para o Yoshihiro entrar mais nos assuntos pormenorizados e técnicos para vocês, e, é claro, vou estar disponível aqui junto com ele para a gente poder esclarecer qualquer tipo de dúvida de vocês. E aí, mais uma vez, agradeço a oportunidade.
Obrigado, Debora. Thank you very much, Debora. That's really helpful. And Yoshihiro, if you would like to just say, perhaps we could leave the actual presentation for a couple of minutes, and so just not to break the dynamic of this webinar, but if you could just give us an idea, a quick idea of, you know, especially timing, when you guys believe we could expect, if that is possible, to see a resolution.
Boa tarde, Pedro. Boa tarde a todos. Realmente, essa é uma pergunta que está nos motivando há algum tempo. Se dependesse da agência, de tantas discussões que nós já tivemos, já avançamos nesse assunto, já deveria ter sido publicado. Só adicionando na resposta anterior da Debora, a minuta de resolução já passou por uma consulta pública, né? Fizemos várias reuniões participativas, várias contribuições muito valiosas do setor, contribuíram bastante para a gente melhorar o formato dessa minuta, e ela retornou, foi submetida depois dessa avaliação dessas contribuições, ela foi encaminhada para a nossa Procuradoria Jurídica, que se manifestou a respeito da resolução, fazendo alguns apontamentos que a área de regulação vai endereçar, né, no sentido de que a gente amplie ao máximo, a gente vai reiterar a necessidade de ampliar ao máximo a possibilidade de opções de títulos minerários a serem ofertados como garantias, e a ideia é essa. Durante esse processo, inclusive, foi interessante, e aí esse é o ponto que a Débora colocou, já que vamos ter essa nova oportunidade de reavaliar aí alguns pontos da resolução, essa questão dos royalties ela é muito tempestiva, ela é muito interessante, e a ideia de participar desse webinar é importante, até para que a gente, como agência, entenda melhor esses assuntos. A gente não vai se furtar de fazer reuniões participativas para debater o tema. Estamos avaliando se nós incluímos já esse tema nessa resolução, né, ou se deixamos para um próximo capítulo, né, dada aí o nível de complexidade do que a gente for fazer. Mas algo que não se discute, para nós é inequívoco, é que é necessário haver essa regulamentação para ampliar e dar mais segurança jurídica para o setor de mineração e para os financiadores.
Uhum. Obrigado, Yoshihiro. I think we all would like to see the royalties properly seen in this very resolution and not the next one. But let's talk about it and see what we can and how at least the basic principles, if those could be covered in this forthcoming resolution, that would be very important, I think. Pedro, Paulo, and Leticia, please, if you could just explain a little on your positions at the BNDES and your experience with royalties, that would be very good.
Okay, good afternoon. Thank you for the invitation. It's a pleasure to be here and talk about paving the way and strengthening the pillars for royalties in Brazil. So, Pedro, I work in BNDES with market intelligence in the basic industries. So I cover the mining sector for, I think, 7 years now. And we are being aware of what's going on and the transformation that the sector is passing through the last years. So it's very good to be here discussing about royalties. First, I'd like to reinforce a little bit about the dynamism that the sector is facing in these recent years. That is in part response to this modernization agenda put in place by Brazilian government, as we can hear now. So after a good moment of the market that we watched in 2011 or 2012, now we are watching again the development of important projects in Brazil. So which we can mention Aripuanã project from Nexa, Atlantic Nickel from Mapian, copper projects of Avan, Conauas Minerals in Carajás province, Sigma Lithium, Araguaia Nickel from Horizonte Minerals, also gold operations and development by Aura Minerals, that in fact was very successful in their IPO in Brazilian Stock Exchange. So we have a lot to believe that we are facing a new moment in Brazilian mining sector. And this moment of the market, together with the continuity of the Brazilian regulatory modernization, gives us extremely favorable environment. So for finance institutions as us, BNDES, to reassess our investment strategies with the intention of making more projects viable in Brazil. So we've been following closely the actions taken by the National Mining Agency and also by the federal government. So they may look for our strategy and realize which further steps we may take. And regarding these actions, I think it's important to highlight also the mining and development program launched last year by the federal government. It's a very huge program with a lot of goals for Brazilian mining sector, and the program includes very specific goals related to mining finance. So as the Brazilian National Development Bank, we are one of the biggest long-term financiers in Brazil, very used to traditional debt, structured finance, and also project finance, mostly for infrastructure sector and not yet for mining. And because of this, we share with our team there a great experience in analyzing big projects regarding their compliance with the agents' rules and other regulations, aspects such as environmental or land framework, and also with ESG practices. So this is which is a very, very important issue for us now to really assess what kind of ESG practices the companies have been taken. And specifically in terms of royalty agreements, it's good to tell here that as a royalty holder, that we also have some few royalty agreements. So we are royalty holder also expect to have our interest secured as every other royalty holder and publicly known by other investors. That's something that I think it's very possible with the new regulations. And as a lender, we need to be aware of all other agreements that compete for the same flow of resource. So, which is very important also. So that's why we think that having a well-established process for registering royalty deals attached to the mineral rights is so important to boost not just this kind of agreements, the royalties, but also other finance agreements in general that very commonly count on royalty deals in the finance package. So having a trustable way of recognizing these royalty deals or other financial instruments previously assigned regarding mineral rights will certainly make it easier to us explore opportunities not yet considered. That's our main view. So I think Leticia will be able to explore a little bit more of our experience.
Thank you, Pedro.
My name is Leticia. I'm part of the BNDES team of lawyers who provide legal support to financing operations for projects in the mining sector. Traditionally in BNDES, BNDES has a guarantee policy that applies to all financing operations with no specification by sector. The rules are also vary according to the type of financing structure, whether it be project finance or corporate finance. In financing mining projects, there are cases in which the guarantee package consists of a pledge on the mineral rights of the enterprise, in addition to other guarantees, such as a standby letter of credit, corporate guarantee, escrow account, receivables, mortgage, and pledge on equipment. But in all cases, the guarantees on mineral rights are negotiated as additional risk mitigators because the current operation policy, such guarantees cannot be only financing guarantee. We have indeed been there have indeed been projects in which BNDES, as the government representative, is in a privatization of Companhia Vale do Rio Doce in the 90s, when has been assigned royalty deals with mining companies which bought the mineral rights, but they are just a few contracts. We don't deal with this all the time. And what I think I can contribute to our discussion today is a bit of my vision about what we seek when we analyze a mining project and the measures we take to bring legal certainty to BNDES as a financer. In financing a mining project, BNDES analyzes the mineral rights that supports the financing enterprise. We normally request the agency certificates regarding the good standing of the mineral right holder and the fulfillment of its legal obligations, and the entire content of the mineral rights transcription in the agency registry, containing the relevant notes and annotation, as well as attesting that the mineral right is full and free of charge. Thus, even if the mineral right is not part of the financing guarantee package, we have the concern about this type of information, precisely about assessing whether there is any risk to the revenues of the future undertaking arising from the said right. And this new regulation goes a long way regarding its publication and transparency, since it allows information about liens and charges on mineral rights to be easily obtained in a unified database. About royalty deals, I think that the possibility of registration is is relevant, providing transparency, the ability to contest third parties, and the legal certainty that derives from the certainty that if the royalties contract exists, this information will be centralized in the agency records. In addition, it will be advantageous for the regulation to determine whether the royalties contract is valid or not, even if the mineral right is sold. And furthermore, if insolvency and bankruptcy events can nullify a royalty deal, just like another contract obligation. And more than bringing our experience here, I understand that for me and Pedro, Paulo, it is very relevant to participate in these events, like today's webinar, so that we can follow the discussions involving securities over mineral rights and royalty agreements. And in this way, we can propose the discussion internally to BNDES and contribute to the possibility of incorporating this type of instruments into our operational policy.
Well, that's excellent. It's really good to know, Leticia, that you're also open to incorporate your royalty deals, and you just confirmed what I have always seen, that royalties are in fact very traditional, to the effect that even in the 90s, during the privatization of Vale, the BNDES is figuring as a royalty holder itself. So I think that's it might be news for a lot of our audience. So now I think we have briefly given our viewers a background that, the discussion is around, of course, this new resolution that is coming out. And but I think we should dive in a little, if I may, on the actual royalty transactions. So Randy, perhaps if I could start with you, and if you could give a brief idea of your of Royal Gold and the model you guys have. And particularly, I think it would be nice for our viewers to understand a little why it would make sense for a mining company from Brazil to reach a company such as Royal Gold, Mavericks, or Vox for a royalty financing.
Happy to do that, Pedro. First of all, thank you for the invitation. On behalf of Royal Gold, we appreciate having this opportunity to share the industry view, at least from our perspective, with members of government and BNDES. My name is Randy Sheffman. I'm, as Pedro said, the Vice President General Counsel of Royal Gold Inc. Royal Gold is a U.S. headquartered provider of royalty and streaming finance to the mining industry. We have offices in the United States, Canada, and Switzerland, and from there, we finance mining operations worldwide. And we consider Brazil to be a very attractive jurisdiction for our particular kind of investment, certainly from a geologic point of view. And in fact, we hold royalties in Brazil at this time on Amarillo's Mara Rosa project and on TriStar's Castelo de Sonos project. And forgive me if my pronunciation isn't quite right. You know, Pedro, I would say that the mining industry, to answer your question, looks to us and to my other colleagues who are participating in this call, as well as the other members of our industry, to provide low-cost, long-term financing that is not traditionally available either from lending institutions or through the equity markets. And because of that, we occupy a unique sector within the typical financing package for a project, whether it be project finance or otherwise. And I guess I would say off the top that any enhancements to legal security in respect of our rights as a royalty holder are obviously of interest and will certainly make the Brazilian mining industry even more attractive than perhaps it is at this moment to our industry. Maybe it'd be helpful, Pedro, if I just sort of gave an overview of our view of a typical sort of bid-ask in a royalty financing transaction, and then I can provide a few more comments. Sure. So in a typical royalty financing transaction, the royalty financier offers the mining company a lower cost of capital generally when compared with debt and equity, at least over time. You know, debt is particularly attractive at this moment, but if you look over the long arc of a project's life, generally speaking, royalty companies offer lower cost capital than both debt and equity. And we differentiate ourselves generally, again, from both debt and equity in terms of the commercial terms on which our financing is provided. In return for that low cost financing, the royalty holders typically receive an interest in the project that lasts for the life of a project, or at least until, or for the life of the related mineral rights. And if a project is successful, continues to grow its resource base, say through exploration, that royalty interest can last a very long time, even into perpetuity. And particularly, I would say, when the investment is made in an early stage project, as with the two interests within our portfolio that I mentioned a moment ago, you know, at either a prospecting or evaluation stage, the royalty holder does not expect to receive a return of its invested capital, leave aside a financial return on that invested capital, for many years, even decades in some circumstances. So the typical royalty investment is a high risk proposition when you consider all of the stages of life cycle that a mining company can go through various commodity price environments and other corporate events. So security of the royalty holder's rights across that span of time is critically important where it's possible. And any enhancements to local regulation within Brazil that contribute to that security of tenure not only reduce that risk for the royalty holder, but allow the royalty financier to de-risk that investment and in relation offer lower cost financing to the mining company. So there is a benefit, I would say, to the regulations being considered not only for royalty companies, but also indirectly for mining companies as well.
Well, I think that was a very good introduction to the royalty scenario. And perhaps I'm gonna pass to Warren and see. Warren, would you kindly share with us what typically you would go after in terms of the actual agreements? Because of course there are various forms of royalties, right? In terms of a participation, what would you at Mavericks, what you usually do and what you see in the royalties spectrum.
Sure, happy to. Just quickly, again, I'd like to echo Randy's comments as well too. Thank you very much for the introduction to be here. And I think what's happening with the changes being proposed in Brazil is a very exciting step forward. And certainly for me as a lawyer that operates in this space, it's very exciting. It's very interesting to see that. So I wish you guys well and as this develops. I'm the General Counsel and Corporate Secretary for Mavericks Metals. We were founded in 2016 as a royalty and streaming company of a very similar model to Royal Gold and to Vox Royalty as well. And to answer your question, yeah, there are many shapes and sizes of royalty as a form of alternative financing. And I just want to take a step back. When I often discuss this, I always talk sort of more in a general standpoint. I find it's a little bit easier to kind of digest this particular topic we move through. And the one thing I always like to toss out at the start is I'm not really a believer in the standard form contract. Like there is no standard way to do these things, but over time, what has happened as royalties have been around for a long time, certainly in North America, there's been a sort of a generally accepted status of provisions or a market understanding of how these contracts will come together and what you will see in them. From the outset, when we're talking about a royalty, what we're talking about is a contract, an agreement, an arrangement between the royalty holder and the operator or the owner of the mine or project or property. And typically, what that arrangement is in exchange for some form of upfront capital or investment in the project, the royalty holder is going to have a right to either revenue or production or a percentage of it from that operation. Now, with the royalties themselves, like I said, there's no standard way to do this, but there are a few forms that you will see time and time again. And the most popular one you'll see is what we refer to, certainly in Canada and the US, as the net smelter return royalty. So what you're seeing there is the royalty holder has a right to the percentage of the revenue coming out from the smelter or mine where the metal has been sold to, less certain specified deductions that are in the contract itself. That's a very popular form of royalty, and it comes up time and time again. That can be different from when you see the gross revenue royalty, where you're just taking, a percentage of the top line revenue from the particular operation. And there's even the concept of a net profits interest, right, where you're actually just getting a percentage of the net profits for the operation, the company overall, not necessarily tied to a specific operation. There is one other form of financing, which I think Vox, Royal Gold, and we all do as well too on the side, which is not different from a royalty, but it's the metal stream as well too. So in that instance, right, it's different from a royalty in the basis that we don't necessarily in North America have an interest in the underlying, it's an indirect interest, but not necessarily an interest in the land itself. But in that scenario, we will be providing an upfront payment to a particular operation, and then we have a right to purchase a certain percent of the metal output at a reduced price over time for the life of the mine of the project. But and just jumping back to what Randy said, why I find this so interesting with what's happening in Brazil is just the longevity of these arrangements that we have. Like they're typically for the life of the mine or for the, they can continue. And certainly on an exploration or development asset, I mean, it's just that certainty to the royalty holder that there's some security over the tenure, because it could be years before that operation comes into production. So it just provides more certainty in what we do. And again, I think it's terribly exciting.
Indeed. And before I move on to Kyle and Simon, we always see comments that in-kind royalties would be unusual, but and I would guess that is correct. How do you?
Not necessarily incorrect, but I think in my experience, and certainly the other panelists can weigh in, but typically for let's just isolate the NSR as an example, I might see an option in that contract where instead of taking a payment in cash, I would be able to take a payment of my royalty in kind, meaning an actual just delivery of, say, gold from an operation, right? I don't think, in kind are necessarily like an outlier, but I think it would be a common market example. You would see those provisions, an ability to take an in-kind delivery in most royalty contracts that are drafted. And certainly, I mean, that when I mentioned the stream would be an example of taking in-kind delivery from the operation, right? Because I'm paying to purchase output from the mine, be it gold, silver, copper, whatever. So I think definitely when you look at a royalty contract, one of the first things I'll kind of check to see is what variations on payment or delivery are available to me on that contract. Or if you're creating the royalty itself, you can make provision for taking in-kind delivery or in-kind payment.
Great, excellent. I think that's it's the same reality we see in Brazil. The royalties that typically we have seen most recently were NSRs or GSRs, and to the most we would see royalties on a profit base as NPIs. It's not unusual to see those. But it's good. It's good to see, and for our viewers to understand that there are, a variety of principles that you can actually apply and discuss. And it's not, as you said, Warren, very well. It's not a standard form and a unique. It's a principle and a concept that you can develop on it, right?
I think one key, just not to continue hogging the spotlight, but one thing to think about, one word to take away from what our companies do is flexibility. Certainly these types of arrangements provide a lot of flexibility that you might not see in a traditional debt or equity financing arrangement, right? There's a lot of things we can do in the contract to benefit not only the company, the project, to align interest, I think much more than in your traditional loan agreement or equity financing. They're just very flexible arrangements, and streams in particular can become very flexible. They're very bespoke agreements. So just a takeaway for the attendees of the webinar.
Great, excellent. So moving to Kyle and Simon, thank you also for joining. And I think I would really love to hear from you is that another aspect of this royalty spectrum that somehow it's not as well known in Brazil as internationally, which is the fact that royalties, after they are created, it is very typical for other royalty companies or third parties to actually negotiate and acquire those royalties. So there would be a secondary market, so to speak. If you could develop on that would be great.
Yeah, I appreciate that, Pedro, and thank you for organizing this webinar. I think it's a really important discussion that's nice to see the Brazilian government spearhead. It would be nice to see more governments around the world really bring some more certainty around royalties and the way that they're registered and secured. From our standpoint, royalties really are a critical part of the natural resource ecosystem. Royalties present an opportunity for whether it was the explorer or prospector or previous company that puts in a lot of the hard work finding these deposits that really boost the national economies. It's a very important part in terms of them maximizing that value and having future upside, because a lot of the times in the ecosystem of mining, they might discover this deposit, but then decide to sell this asset onto a major mining company or another group. And so a lot of times what they're left with is the royalty interest. And the more valuable that royalty interest, the more incentive there is to go explore and develop future projects. And that obviously helps the entire ecosystem of mining and certainly the tax base for the local governments. So from our standpoint, everything the government can do to make that a more safe, secure, and transparent marketplace is beneficial across the mining ecosystem. From our standpoint, Vox is a global company. We've been around since 2013. We've been the fastest growing royalty company. We essentially look for what we call third-party royalties, which is royalties that were created in a transaction and usually held back by a prospector or a mining company as a way to retain some future interest in the development of these projects. And so that secondary marketplace really increases the value of the work that these parties have done to move and find these projects and interesting deposits. And so the more clarity and certainty you have from a governmental regime perspective over these, whether they're NSRs or over these various types of interests, the more valuable that those interests become and easier to transact on. And we believe that increases the value to the entire ecosystem that relies on mining and natural resources.
Excellent. Simon, would you like to add a couple of things? I know, Simon, of course, that you have a clear, and very good financial view. And of course, we always talk about royalties, and typically, and that was on purpose that we focused on royalties, and we're not as mentioning streaming as as much as royalties in this specific webinar. Perhaps for chapter 2, we would expand on streaming itself. But what I was wondering is, typically when you're evaluating this type of transactions, do you see a financial rationale for companies to choose a royalty rather than streaming, and how important it is for companies to put this all together and think ahead in a couple of years how the royalties or the streaming will sit together with other types of financing, either being equity or debt?
Sure, we're probably less qualified to talk about the streams as opposed to the royalties, just because the business model for us is to really focus on that secondary royalty market for the most part, and the acquisition of existing royalties. But I mean, generally speaking, when you're looking at a royalty or a stream in the context of a greater financing package, like all things equity, debt, royalties and streams, the reality is that you do have to find a balance with respect to, how that ultimately looks on the actual operation and the viability of that operation. Obviously, there are certain assets where streams make a lot of sense as perhaps a byproduct of the primary commodity that is being mined. And again, so you do have to look sort of generally across the financing package and make sure that, as with say debt, you don't overload a project with debt. You'd look to do the same with a royalty and a stream and sort of just model that out over the life of the asset. But again, for us, it is predominantly focused on that secondary market and looking for existing royalties, and it is just as important for us to have the ability to go and register those royalties as an interest running in the land, because if the project ultimately changes hands after we come in and having acquired that existing royalty, it helps us mitigate our risk in terms of making sure that that royalty remains in good standing.
Excellent. Thank you, Simon. And you mentioned, and you and Kyle, specifically on the secondary market and the importance of having, a clear way of showing and ensuring that assignments and transfers are properly registered with the mining agency. And that I would also mention something that is, unfortunately, it happens quite often, is that given that, of course, mining is a very old activity, and many of these properties have been changing hands throughout the years, it is not unusual for a company to realize that, some decades after buying a certain property, that there was a hidden royalty, which it's quite a problem, because you can have, especially if if the royalty holder would have a registration with the Registry of Titles and Deeds, which would make that specific agreement enforceable against good faith parties. That could be a problem, because it could make it enforceable even against a new holder. So it's of course it would be a litigation, it would be a problem. So that's the type of thing that would certainly be improved if we would have a registration proceeding very clear, where these hidden royalties could come to light, and so that in any type of transaction, M&A, financing, whatever, companies and institutions could easily have access to the public records and check whether there are any encumbrances, such as royalties and the like. So I don't know, in terms of comparison, perhaps, if I may go back to you, Randy. I know, of course, that it makes quite a difference in terms of countries that have civil law and countries that have common law. But you know, for a company like Royal Gold, which, you know, have international transactions, of course, it's difficult to say that it would be applicable to all countries, but I understand that would affect, at the end of the day, the cost of capital, right? If, you know, the more attractive it is and the more secure it is, right?
As to that last point, Pedro, no question. You know, going back to what I said a moment ago, anything that can be done to reduce the risk to our return, not only it helps our business and encourages us to make further investments in that jurisdiction, but it enables us to offer lower cost capital than we might if we had to risk adjust that investment for a less secure environment. To your first question, you know, certainly in the United States, and perhaps my Canadian counterparts on the panel can address the situation better than I can in Canada, but certainly in the United States, a common law jurisdiction, it's possible to have fee ownership, direct ownership by a company in the mineral estate, so in minerals in the ground. And as in relation to that, it's possible in the United States for a royalty holder, debt financier, another holder of a secured right granted by the mining or the mineral rights holder to have its interest attached to those minerals, and to use the phrase that Simon used a bit ago, to run with the land, meaning that the royalty holder's rights follow title to that property through any number of changes, either in the identity of the mining company, by merger, by acquisition, otherwise, or indeed through insolvency proceedings, which is a very important element of US law, and again, I'm not the expert here, but Canadian law, and in some ways, law in other common law jurisdictions such as Australia. And because that element exists where the royalty holder's right can survive through all of those changes in the identity of the mining company and indeed the insolvency of the mining company, royalty financing has been a considerable part of what Kyle referred to as the mining ecosystem for decades, if not longer. I contrast that, though, with my general understanding of civil law jurisdictions, and my understanding is that Brazil sort of follows along here, where the mineral wealth is considered to be owned by the state. And while mining companies can obtain a license, just using that term generally, to develop and sell those minerals under certain conditions, it's generally thought that if the mining company sort of fails to meet those conditions or has some other event such as an insolvency occur in its lifetime, then those rights go back to the state. Perhaps there are certain circumstances in insolvency where they can be transferred, but that difference, I think, separates civil law countries and common law countries. And I'm not here suggesting that Brazil should rewrite its constitution to become a common law country. I would just make the same point that I made in the beginning of my remarks, which is that anything that can be done to increase security of tenure invites more capital into the mining industry, particularly through royalties and streams, which at this point in time make up a very important part of the capital tower for a typical project. I hope that answers your question.
Yeah, no, definitely. I think that was very good. And you mentioned briefly insolvency, and so I'll bring us to perhaps a more complicated issue, which is stress scenarios. So when everything goes right and payments are fine and you have all the registrations, it's all fine. But we have to think that typically royalties and please correct me if I'm wrong, but traditionally royalties and streamings are not the main project finance for major construction. And so typically mining companies will have to, have some sort of equity and project finance with further security over the properties, equipment, and so forth. So it is one very typical issue that comes out is ICAs, of course, the intercreditor agreements. And that would be very important in the context of these resolution and the new regulations, because the effects of having a registration of a royalty, and perhaps even better if we would have potentially security in different rankings, and having the intercreditor agreement, and that to a certain extent, of course, we wouldn't expect the agency to incorporate all of the provisions of the ICAs, but to some extent to have clarity on perhaps the rankings. To me, it seems that could be a good idea. So I think, given that in this mix of financings, it is very possible that the BNDES may play a role in that. I thought perhaps I will start with Leticia and see, Leticia, how would you see these type of royalty transactions sitting with your typical intercreditor agreements and a broader financing mix?
I think my internet was unstable I didn't hear the last part of what you were saying. Are you hearing me?
Yes, I'm hearing you well. And it's yeah, well, I was asking you about the intercreditor agreements, and how do you see the royalties coming in the context of a broader mix of financing involving the BNDES?
We don't have many examples in mining projects involving project finance. We have more corporate finance, so we don't have many intercreditor agreements to comment. But these intercreditors we celebrate when we are sharing guarantees with the other lenders. I think if we were going to share the royalties in different percentages, I think it's possible to celebrate an intercreditor with, I think we have in the bank concern on the conditions of our credit. If they are similar to the conditions of the other lenders, we are going to seek equal participation in the royalties and guarantees. I don't know if I answered.
Right. Yeah, no, definitely. It's good. I think it's good to hear that BNDES is would be open to have an ICA that would involve perhaps a royalty transaction as well, a royalty holder. I think that's good for mining companies that are listening to us to hear that. Of course, you're not defining it by now, but just giving a first impression. I think that's very good. So from a royalty company, perhaps Warren, how would you react to these type of ICAs and also involving perhaps a local development bank such as the BNDES?
I would like to think, personally, I like to try and get along with everybody. It's not going to benefit the project if there's a role for the royalty company to play in the investment, and they also need to pursue some alternative form of, other form of financing with a bank or development bank, I would like to think that Mavericks, and as a royalty holder, we can find a way to get along. And to that end, the process I typically take was I have developed for Mavericks a set of sort of intercreditor principles that would guide sort of what I would like to see in that type of relationship, right? And understanding, I have to be very understanding of where my position would be in the ranking as well too, because that will determine sort of what I might push for or ask for, what becomes important to me. I mean, if I'm the first ranking creditor, then I will find a way to efficiently sort of share the underlying security base with the other lenders if they so require it. Typically, with Mavericks and the size of the operation, I might actually not be at the top. I'll be somewhere in the middle, maybe. So what I like to do is make it clear to the other lenders, what's important to me as the royalty holder, right? And that's my royalty contract. That's the right of revenue I've got coming from that. So I will typically, not to give away too many secrets to other people on the call, so don't hold me to this if we find ourselves in a negotiation, but I like to see the continuation of my agreement. I like to see the ability to purchase that asset or repurchase or transfer it out of an insolvency. I'm looking for certainty and continuity of my investment in the face of other uncertainties that might happen with somebody else holding the sort of the prior ranking security. It's a large topic to unpack, but I do want to stress that as a royalty holder, as part of the ecosystem, I mean, we all have to get along at some point, but we all have objectives that we're trying to obtain in those relationships. And what can be handy is, some of the lenders have a set form of intercreditor arrangement that they'll typically use, and you can kind of get familiar with those if you're doing repeated business or bumping up against them. But any kind of certainty that extends into a development bank that has a way it needs to conduct those intercreditor relationships will help, and will certainly lessen the administration, lessen the upfront cost of putting those into place. So the sooner you can engage with another lender or another party that has an interest in the operation, the better, is kind of what I said. And again, just stress, I like to get along with everybody. That's perfect. And so, Randy, would you, in that, in that connection, would you say that because that in a way royalties on revenues could be a barrier for future financing? Because sometimes, as I said, I see especially junior companies that when thinking of the capital matrix, they do not properly consider, and sometimes either or they go too far in the streaming, compromising a portion of production which would be excessively high, and that would affect valuation at the end of the day. But how do you see that in the context of royalties? Do you also see, depending on the revenue compromise, do you think that could be problematic going forward?
Well, I guess first I would echo Warren's comments. We certainly take a similar approach. And going back to, I think, Simon's comments from a moment ago, we would not look to place a royalty or a stream on a mine in a way that would ultimately condemn the for other financing, because that doesn't serve our interest any more than it serves the interest of the miner. We want to see good projects be developed. I suppose the answer to your question, though, depends upon the amount of capital required by the mining company at the time that the royalty transaction is entered into. And I think that probably dictates a bit of the positioning that Warren was mentioning, depending on the relative risk and the amount of the participation that the royalty company is assuming. We may see ourselves as the lead financier for the project, understanding that there has to be other capital available, or just a piece, which is more generally the case of a larger capital package for a project. So I think the flexibility that Warren referred to is absolutely critical. But at the same time, it's helpful for project financiers in particular to understand that security of tenure, because of that long dated investment thesis that I mentioned is of the most critical importance, I think. And I don't want to speak for Vox or Mavericks, but certainly from our perspective, it is the most critical. And as long as that is acknowledged through that life cycle of transfers, assignments, insolvencies, etc., that I mentioned, then as a royalty holder, we can generally become quite comfortable with placing a significant amount of debt or another interest ahead of our own.
Excellent, thank you. That's very helpful. I would like to make a quick question to Yoshihiro. One of the practical aspects that usually would come out when discussing royalties and streamings as well in Brazil, because of the upfront payment that typically is offered when the upfront payment is offered directly to a Brazilian company, a subsidiary of an international group or a typical Brazilian company. When the upfront payment is transferred to Brazil, there are some discussions on how do you actually account for that specific upfront payment, and which have an impact on how do you treat that from an accounting perspective, and ultimately the tax impacts of that specifically upfront payment. And of course, Yoshihiro, I'm not putting you on the spot to respond on the tax issues, but I wanted to. It's a question and also a suggestion implied, because we have these tax issues that really depend on further regulation, and of course that would be on the federal revenue, not on the agency. And we also have discussions over the actual registration of the upfront payment with the central bank, given our foreign exchange regulations. So did the A&M by any chance have any contribution in the context of the resolution that would raise the discussion on the need of further regulation by the federal revenue and the central bank to have more clarity on how to implement this type of royalty financing? And if the answer is no, I will dare to make a suggestion that the agency liaises with the federal revenue and the central bank to make it clear, on how to treat the upfront payments, either on royalties and streaming.
Obrigado pela pergunta, Pedro. Então, quando nós começamos a discutir o tema e cumprir o que define o decreto, nos artigos 43 e 44, sempre me pareceu muito direto, muito simples o que a agência tem que fazer, né? E conforme a gente vai debatendo e se aprofundando sobre o tema, a gente percebe a complexidade que surge e realmente a necessidade de haver uma articulação entre a agência e as outras agências, né? Você citou aí o Banco Central e a Receita Federal. Eu acho que é necessário sim, mas nesse momento a resolução ela não versou sobre isso. Você começou a falar isso, eu falei, não tem. Aí você já respondeu e já me tirou do holofote de fato. Mas realmente eu acho que é como a Débora falou no começo, nós estamos começando a trilhar esse caminho de dar segurança jurídica, previsibilidade, estabilidade, que é isso que importa, né? Para a gente reduzir custo de capital e ter um mercado primário e secundário, como foi colocado aí, mais atraente para o investidor nacional e internacional. A agência, a gente está envidando esforços. Acho que na primeira pergunta, inclusive, eu fugi da resposta. Acabei Quando que foi? Acho que a principal pergunta, né? Quando? Nós estamos aí com essa perspectiva de final desse mês. É sempre difícil se comprometer com datas, mas estamos aí trabalhando com o final desse mês, no mais tardar meados do mês que vem, para que a gente tenha uma decisão aí da diretoria a respeito disso, né? Porque já passou pela Procuradoria, a gente está endereçando as questões que foram levantadas ali, queremos, inclusive, incluir ao máximo dessas essas novas nuances a respeito de formas de financiamento, que não apenas o direito mineral como colateral, né? Mas também essas vendas futuras, esses derivativos. Então, eu acho que certamente vamos ter que evoluir nessas regulações. A agência, como eu falei, né? Evoluir no sentido de articular com as outras agências, ver como é que a gente consegue contribuir de uma forma mais organizada, né? Para que haja essa sinergia. Porque no começo, como eu falei, basicamente parecia muito simples a questão, e conforme a gente vai se debruçando melhor sobre os pontos e debatendo, essas reuniões são muito importantes para isso, para a gente ampliar essa perspectiva. E, assim, a ideia é fazer passo a passo, não ficar querendo entregar a melhor solução possível, porque isso vai demandar mais tempo. Então, a ideia é a gente fazer progressivamente essas caminhadas para melhorar esse cenário de segurança jurídica que hoje realmente está muito nebuloso, né? E a agência vai começar a dar esse primeiro passo.
Excellent. Obrigado, Yoshihiro. Thank you very much. And I think that's, as you said, there is an active secondary market, and I would like to go back to Simon quickly. Just Simon, there is another aspect that there are actually two aspects that I don't think we touched yet. Which first is the real possibilities that mining companies do have to monetize some of those existing royalties. I think that that's something that I typically see even other junior companies, some of those have reduced or even stalled the operations, but they're still royalty holders. And they somehow do not have a clear idea that companies such as Vox have a direct interest and could monetize on those royalties, existing royalties, right? And finally, I was thinking there are many, our viewers. It's a quite broad range of banks, investors, and so forth. And so I was thinking, what is the rationale for an investor that is not interested in the royalty itself, but rather on investing in the royalty companies? Because the model, and we've seen in the market, the royalty companies performing really well in the markets. And so what is the rationale behind a royalty company there's specialized in this type of transaction?
Sure, absolutely. So you're absolutely right with respect to that secondary market of royalties. And I think one of the benefits of going out and acquiring existing royalties in that secondary market is that you have the opportunity for those existing royalty holders to realize some liquidity and really sort of bring forward revenue from their royalty interest if they choose to sell that interest to a group like us or Royal or to Mavericks. So let's say, for example, and a great example is we have two royalties currently within Brazil, and it's certainly the case for one of the royalties that we acquired within Brazil. Let's say we purchase a royalty from a mining company that may then in turn look to, I guess, reinvest the use of those proceeds into other operations that they have within Brazil. And again, that was the case for one of the royalties that we acquired from an entity that had other projects. They then sort of deployed that into exploration and development of those other assets that they had and moved them forward. So I guess having that buoyant secondary market is, as Kyle alluded to, and is a good thing for the ecosystem as a whole. And we see it a lot. Particularly in some other jurisdictions where we go and acquire royalties, as you said, from junior mining companies, and then that allows them to sort of free up some cash and put that to work on their other projects. And then I guess generally, I mean, there's a whole slew of benefits as to why, you know, investors would generally look at sort of royalty and streaming companies as a whole. But one that I like the most, outside of some of the typical ones, is I guess investors look at a royalty company, or when they invest in a royalty company, they're not just gaining exposure to one particular project, one particular asset in one particular part of the world. They gain exposure to a whole portfolio of different royalties and streaming interests, again, across different projects, across different operators, and in many cases across different commodities and jurisdictions. So I think that diversification of risk and also that diversification of having exposure to a whole slew of different projects is, for me anyway, kind of one of the big you know, benefits of people looking to invest in royalty and streaming companies directly.
Right. Got it. So at the end of the day, investors would have a different way of having some exposure to commodity prices and the like, and a diversification, but not necessarily through a direct equity in mining companies, right? So I think that's that might explain quite a lot in terms of the performance of the royalty companies in the markets, which is truly fantastic. I think we're coming to the end of our webinar, but I just wanted to make a final question to all of you in terms of for the junior mining companies and the ones we are going through a change in resolutions, in modernization of regulations. We now have the online offers and tenders for thousands of new tenements. So hopefully all of those great initiatives by the agency will boost mining projects, and we will have many companies around that will be going after financing and capital raising. Perhaps I would start with Warren. It's what happens when a company actually, you know, gets a royalty from a company like Mavericks and starts a relationship, because one of the pros that we all see is, of course, that in a royalty transaction you don't dilute your equity, but still in royalty agreements you have several ways of controlling. Of course, the royalty holder has to control, has to interfere, but that to what extent that differs from having equity investors sitting at the board and from in a day-to-day influence, so to speak.
I think I'd like to characterize it when Mavericks conducts and concludes an investment. I think we would look at it and evaluate it as a strategic partnership, because our interests would be aligned with that particular operator. It's you know, there is some policing that will go into these things, but that's just the administration of the contract itself, which is no different than a loan contract. Every royalty agreement is different, and so depending on the nature of the relationship between us, which is defined by the agreement, we would, you know, make sure that everyone is abiding by their terms there. But specifically, we really do characterize it as a strategic partnership. We have an open line of communication and dialogue. We like to know what's going on with the operations, if there's any way that Mavericks could continue to help augment, change the relationship, any new developments as well too. I mean, particularly on the streaming side, and I think Randy hit on it as well too, and so is all the royalty companies have, like, we're not going to overburden an operation, because that's just not going to benefit anybody involved. And for the royalty and streamers, what's so unique about us and what sets us aside from the other, you know, the traditional forms of financing, is that alignment of interests, right? We all want to see the project succeed and grow. It's the best for us, it's the best for the company, it's the best for that company's shareholders and our shareholders as well too. So we really do value it as a partnership moving forward, and we just look to make sure that the terms of the contract are abided by, and there's information flow and a dialogue is established and maintained. That's really important for Mavericks, is that line of communication first and foremost.
That's really good. Randy, anything to add in that respect? And I was wondering if that might change that scenario where a royalty and streaming company would typically have a lower level of interference in the operations. But if that scenario would be changing because of the ESG requirements, how do you see that?
Well, I guess first I would just underscore what Warren said. We view our relationships with our contractual counterparties as strategic alliances, and we aim to work together for mutual benefit. ESG is obviously a growing area of concern, and I'm very pleased to hear that it is gaining import from a regulatory perspective in Brazil. You know, ESG for Royal Gold has always been a part of the way that we do business. Again, because of the long tenured nature of our interests, anything that can create sustainability for the project contributes to the viability of that project and thereby our interests. So ESG for us has always been an important part of what we do and an important part of what we look for. Strong management of ESG, particularly relationships with communities, but also other aspects, an important part of what we look for in new opportunities. You know, I wouldn't say, given that the sort of heightened regulatory and commercial focus on ESG is going to change the way that we do business in a fundamental way. You might see us being more outward in talking about how ESG influences our business, but you know, we've always made it a critical piece of our own evaluation of opportunities and a critical understanding of how we should align with good management companies good management teams of mining companies who build and maintain strong relationships with communities, who make effective and proper use of resources and develop their projects for the long term.
That's great. Pedro, I of course, ESG is quite an important topic for the BNDES, and I would extend my question to Randy, to you as well. To what extent do you think that financings and the way the bank actually controls and influence on projects after the transaction is implemented, how do you see that changing because of these increasing requirements on ESG?
Well, thank you for the question, Pedro. I think we've seen in BNDES is a bigger effort to try to bring companies to new commitments in terms of ESG indicators. So related to projects itself, I could echo the Randy answer. That doesn't change much because we've already make a very detailed assessment about the environmental and social aspects of the projects. But in terms of indicators of the companies, we are making a huge effort so them can achieve new goals in terms of ESG. And in this scenario, we are also now studying new projects, new kinds of linked loans related to ESG indicators, so as to boost this kind of practices. Most medium-sized companies that we see a great opportunity to engage more in this ESG practices.
That's very good to hear. I think at the end of the day, this whole discussion on capital raising, financing, and mining, at the end of the day, this is all to create value for communities, and this is our ultimate goal, right? So that being said, I really would like to, reiterate my big thank you to each of you. It's been great. We're coming to the end of our allotted time. But before finishing, I would like to open the round table for any final comments that you might have. And hopefully we're gonna have the time to have further discussions, and the A&M, as perhaps Yoshihiro and Debora, they might have taken some ideas for the resolution and seeing the importance of registration, transparency for this type of transactions. So thank you again, and I'll open the floor for any final comments.
May I go first?
Yes.
Vou falar em português, desculpem. Realmente foi muito bom ter participado desse painel. Gostei demais de poder presenciar essa discussão de alto nível. Me anima bastante ver esse tipo de discussão no setor mineral, porque desde que eu entrei no setor, há pouco menos de 2 anos, a gente está realmente tentando ajustar a casa, né, o setor não está muito acostumado com transparência, com previsibilidade, então é nisso que a ANM está investindo bastante, né, dar transparência na decisão. Queremos rever as resoluções que tratam de sigilo, porque hoje praticamente tudo é sigiloso, e tudo que a gente precisa para reduzir custo de capital é transparência, é segurança jurídica e facilidade, né? Facilidade no sentido de que a ANM tem que ter todos os processos digitais, rastreáveis, né? Para que não percamos tanto tempo com burocracia desnecessária. As últimas estimativas foi interessante você ter levantado o ponto das ofertas de disponibilidade. Fizemos aqui algumas estimativas resumidas do impacto financeiro desse custo de atraso. As estimativas aí girando em torno de quase 3 bilhões de reais de redução de fardo regulatório, ou seja, dinheiro que ao invés de deixar de render por conta desse atraso, eles vão, a partir de a gente conseguindo reduzir esse estoque de mais de 50 mil áreas, isso aí vai ter um impacto de mais ou menos uns 3 bilhões de reais em redução de fardo regulatório e atração de pelo menos 1 bilhão de reais em investimentos. Então, é uma contribuição muito significativa desse projeto apenas aí na redução do custo do país, na atração de investimento, tornar o Brasil mais competitivo e um destino talvez aí mais preferencial, né, para os investidores nacionais e internacionais. É isso que a gente quer profissionalizar, quer ver o mercado, o setor da indústria mineral bem pujante e contribuindo com o nosso desenvolvimento.
Perfeito, excelente. Muito obrigado. Anyone would like to say a few final words?
Well, Pedro, I'd like to add that the Brazilian Development Bank, as we mentioned before, is open to discuss new kinds of agreements, of financial agreements. As you asked to explore more about inter-creditor agreement, as Leticia said, we wouldn't have a problem to study the best option for us to partner with other kind of institutions and even other types of financing deals. And for us, it's very good, and we are very welcome to receive other financiers to discuss about new projects.
It is great. Excellent.
Just a quick one from our side. Look, great to hear of the initiatives. I think for us, we're hugely supportive of them. Anything that helps to promote further investment into Brazil is a great thing for us as a group that's looking to gain more exposure in Brazil, and hopefully also good for the Brazilian mining industry as a whole. So, some of these initiatives to help strengthen how a royalty is treated for us as a royalty holder is, certainly fantastic. And appreciate having the opportunity to have been involved there. And Pedro, thank you for organising, obviously.
Absolutely. Thank you, Simon. Warren?
I was watching Randy because we both came on mute at the same time there. I was just going to say thanks again for this participation. I have to say it is really interesting development in Brazil. It's certainly not to be selfish, it'll probably make my life a lot easier going forward navigating investments in Brazil. Because one of the first things that happens to me as the general counsel with the team here is we acquire something and it's okay, how are we going to register this? And then I have to have the conversation like, okay, well, which jurisdiction are we in? What's going to happen? But it's certainly going to make things administratively easier. I think it's going to open a lot of doors to an already very interesting place to make investments. And there's a lot of projects down there. And I think overall, it's an extremely interesting development. And I can't wait to keep watching it further develop.
Excellent.
Oh, sorry. Warren, Simon, well said. I think you covered my feelings, and I'll just go back to something that Kyle said, which is that it's fairly unique. In fact, I think it's entirely unique in the decades that I've been doing this, that government has reached out in such a warm way to industry to invite comment on a critical issue. So thank you very much for the opportunity. We will watch with great interest as the regulations develop perspective, and I'm sure Vox and Mavericks would say the same. We would be quite happy to discuss with you further, whether it's in regard to intercreditor agreements or anything else you may be considering. So thanks for the time, and we'll look forward to the next chance.
Thank you, Randy. It was great. Leticia, would you like to say the final words?
I just want to thank you for the opportunity. I've learned a lot in this conversation, and I think Pedro said everything about the bank. I'm very happy to be here. Thank you.
Well, thank you very much, Leticia, and thank you all. We're right on time, and thank you to all our viewers. We had people coming and joining from various time zones, and thank you very much for holding with us until now, and hopefully we're going to see you in the next webinar. Thank you. Bye-bye. Take care.
Bye-bye.
Thank you.
Bye.
Bye-bye.